Well, this is a significant development coming in from the Supreme Court pronouncing its interim order on the pleas challenging the constitutionality of the Waqf Amendment Act 2025. The petitions that argued that sweeping changes to the Waqf law were said unconstitutional. However, the order that was reserved on the 22nd of May after 3 days of hearing comes amid rising debate on the scope of religious representation in the Waqf institutions. However, the Supreme Court noted that the entire act was challenged, but however, the Supreme Court says that there is no case to pause the Waqf Act in its entirety and, however, has decided to pause or level a stay when it comes to some of the provisions that have been challenged, considering when it comes to prima facie, the challenge to each of the sections and hearing parties that was made for the entire statute. But there are other sections that were under challenge. The Supreme Court for now has granted a stay to them. So let's get in a word from Bhavtosh now. Bhavtosh, when it comes to the entire statute, this is something that the Supreme Court has denied as far as putting a stay on it altogether. But there are certain provisions, 3 main points that are now being talked about as far as the stay has been granted, one by one, and in a simplification of the language. Can you make us understand what these clauses were?
Well, in fact, it's a victory for everyone who had approached the court, and as well as for the centre. The SC has refused to stay the act itself till it gives a final order. It has also, in fact, given. It has in fact stayed the contentious issue of the fact that one has to be a practicing Muslim before they can create a Waqf. In fact, the Solicitor General during the hearing had already said that if the Supreme Court feels that this is not correct, the Supreme Court can stay that order, and also the entire issue of the inquiry by a collector. Now, the Supreme Court has in fact said that one can in fact look into this matter. Provisionally state governments frame rules on determining whether a person is a practitioner of Islam. Central Waqf Council shall not consist of more than 4 non-Muslim members, and for a state for no more than 3 persons. Registration shall continue the requirement not new members. And Chief Justice of India has also said that we have held registration existed since 1995 to 2013, and again now, so we have held registration is not new. We have dealt with the timeline of registration also. Work by user denotification state, designated officers making challenge in revenue records permitting the collector to determine rights would be against separation of powers. So too much interference by bureaucrats has also been stayed. Now, there were opposition leader who has said that once the Waqf Amendment Act is notified and once it comes into implementation, then bureaucrats as well as collectors would have too much of powers. That has in fact been looked in by the Supreme Court. But these are interim orders. As far as centre is concerned, it's a victory, it's a vindication for them, because the act itself has not been stayed. For opposition party, it's also some kind of relief for them, because one of the points that they had stressed a lot is the fact that one has to be a practicing Muslim. He has to be a practicing Muslim. He or she has to be practicing Muslim before they can create Waqf. That has been stayed. So it is in many ways win-win for all, but the detailed order has to be first read before one can. As most of the lawyers
awaiting a detailed order as and when it will be released. There, Ratan Sharda is connected with us, and so is Tausif Ahmed Khan. We'll go for a better understanding of how are they looking at this interim order. Live reactions that are also coming in. Let's get you the reactions coming in from the Supreme Court.
The Supreme Court has first found that there is a prima facie case for stay on certain provisions. They have not stayed all the provisions, the complete act, but certain provisions have been stayed, like the provision that said that you have to be a Muslim for 5 years have been stayed, because there is no mechanism to determine whether the same can happen or not, to determine whether someone has been a Muslim for 5 years or not. Apart from that, the provision 23C, the court has said that until unless there is a mechanism devised, no third-party interest can be created. Nothing can be, the people cannot be dispossessed of their Waqf properties. As far as non-Muslim members are concerned, the court has said that in the Waqf board it cannot be more than 3 and not more than 4 in the Section 9. And on the registration, the court has apparently extended the time limit but has not stayed the provision.
Till the time final decision is taken, no third-party right shall be created. So these are the interim directions at this. So we understand this is a good order. We'll read about Waqf by user and then we'll respond about it. Thank you.
All right. Tawseef, what is your understanding as far as this interim pronouncement of this judgment that is coming in from the Supreme Court, especially when it comes to staying of various provisions of the Waqf Amendment Act under challenging, including the precondition of 5 years as practicing Muslim for the creation of the Waqf itself? We've seen that it was one of the main contentious issues at the time, that multiple petitions that were raised before the Supreme Court.
Well, there is nothing new pronounced today by the court. Right from when the first day when the matter was challenged, the central government themselves had given assurance to the court. I was present in the court the first day of the hearing, where the Solicitor General assured the court that no third-party interest would be created, that they will not be acting on these provisions, specifically these two provisions which the court has put a stay on. So this has been there, not in the form of a proper stay from the judge, from the court, but as an assurance from the central government side. Yes, we are very disheartened. I mean, there are so many other provisions in the Act which is worthy of a direction from the court, a formal order of a stay
because
from the
petitioners wanted, as far as challenging the entire the statute altogether, calling it as unconstitutional. Bhavtosh, over to you. Live reactions coming in.
और कुछ पॉइंट्स तो बहुत महत्वपूर्ण थे और इस अमेंडमेंट को बहुत खतरनाक बना रहे थे, उस पर रोक लगाया है माननीय उच्चतम न्यायालय ने। तो मैं इसे जीत के तौर पे देखूंगा। कलेक्टर राज वाला जो पॉइंट है उस पर रोक लगाना, प्रैक्टिसिंग मुस्लिम पे सवाल खड़े कर देना और उस पे रोक लगा देना, मुझे लगता है ये दो तो बहुत ही महत्वपूर्ण पॉइंट थे।
So one of the contentious issue was of a person to be a practicing Muslim before he or she can create a Waqf. Do you think the stay that has been put by the Supreme Court is in the right direction?
नहीं, 100% पूछा है माननीय उच्चतम न्यायालय ने कि आप रूल तो फ्रेम करो, कैसे डिसाइड करोगे कि हु इज द प्रैक्टिसिंग मुस्लिम और नॉट, हु इज द प्रैक्टिसिंग हिंदू और नॉट, कैसे डिसाइड करोगे आप? तो वो डिसाइड करने का पहले मसौदा तो लेके आओ, तो इट्स गुड। मुझे लगता है कि अच्छा
point that has been stated by the Supreme Court is about the bureaucrats, too much interference by
Day 1 से हम सारे लोग कह रहे हैं कि कलेक्टर के जरिए जमीनों को लूटने की कोशिश है। माननीय उच्चतम न्यायालय ने रोक लगा दिया। धन्यवाद।
The other one is about the representation in the Waqf from
अब उस जजमेंट को पूरा पढ़ने के बाद कुछ उस पर हम बोल पाएंगे, लेकिन जो इनिशियली हमारे पास इंफॉर्मेशन है उसके हिसाब से ये वक्फ की लड़ाई लड़ने वालों की जीत है।
Well, as we have been saying, that till the entire order becomes public, it's a win-win for all. Even opposition parties are saying that Supreme Court has been, in many ways, very just as far as the order is concerned. Center also feels that the very fact that the Act has not been stayed is a victory for them. Imran Pratapgarhi has said that there were some contentious issues that has been stayed by the Supreme Court. So everyone feels that it's a victory for them. Back to you.
होगी ट्रिब्यूनल में, उसमें भी स्पष्ट कर दिया है कि जो मामले ट्रिब्यूनल में चल रहे हैं उसकी ट्रिब्यूनल में ही सुनवाई होती रहेगी, लेकिन जो नया आएगा विषय वो डीएम के सामने जा सकता है, या वो आदमी कोई ट्रिब्यूनल में ले जाना चाहे ट्रिब्यूनल में भी, उसमें कोई अभी तक रोक नहीं लगाई है। तो इस फैसले का मैं स्वागत करता हूं। मैं आशा करता हूं कि माननीय सुप्रीम कोर्ट जल्दी से इसकी फाइनल हियरिंग कर देगा और इसका फाइनल डिसीजन भी जल्दी आ जाएगा।
कुछ वर्गों को संरक्षण देने की आवश्यकता है, कोर्ट ने ये भी कहा।
देखिए, बहुत सीधी सी बात है, वक्फ का मामला इतने दिन से है और लगभग 40 लाख एकड़ जमीन पे, देश भर में 40 लाख एकड़ जमीन पे वक्फ बोर्ड ने कब्जा अपना दावा ठोक रखा है। ये कोई छोटी मोटी जमीन नहीं है, 2 एकड़ 4 एकड़ की मामला नहीं है, 40 लाख एकड़ का मामला है। तो इसके ऊपर पूरे देश में कानून होना चाहिए और जो नया कानून आया है मैं उसका समर्थन करता हूं, इसीलिए मैंने PIL फाइल किया था। नया वाला कानून पूरी तरीके से इम्प्लीमेंट हो चुका है, उस पे माननीय सुप्रीम कोर्ट ने रोक लगाने से मना कर दिया है। इसलिए अब जो नए डिस्प्यूट होंगे वो नए वाले कानून के अंतर्गत जाएंगे। केवल एक मामले पर रोक लगाई है कि 5 साल की वक्फ वही कर पाएगा कि जो 5 साल प्रैक्टिस होगा, उस वाली धारा पर रोक लगा दी है।
All right, waiting as far as when it comes to the detailed judgment to be out there. Harish also continues to be with us. Harish, we have seen both sides have been claiming vindication, saying that this is a call that has been taken in their favor. But as far as the bench of the Chief Justice and Justice A.G. Masih is also concerned, they found that there was no case that was made to stay the whole statute, but however suggested that there needs to be certain sections that need protection.
Yes, that's right, Amit.
the Chief Justice of India emphasizing that there is a presumption of constitutionality as far as act passed by the parliament, by the both houses of the parliament is concerned. So therefore, there can't be a complete stay of the entire statute. So the Supreme Court is of the opinion that till it pronounced the judgment on the 100 petitions which have been filed challenging the constitutional validity of Waqf Act is concerned, some fine-tuning of certain clauses are required. The Supreme Court emphasizing that since there is a constitutional presumption, the entire statute cannot be stayed. And very importantly, Amita, the centre had already given an assurance to the Supreme Court that till the matter is adjudicated finally, it will not press for 3 clauses. And all those have been stayed now. Number 1, no denotification of Waqf by user, Waqf by registration, Waqf by notification. Number 2, the Supreme Court saying that the collector cannot be given too much powers, because as per the Waqf Act, once the collector is seized of a dispute, that particular property ceases to be a Waqf. And more importantly, the petitioners had said that why should the collector be allowed to adjudicate a matter, because in a dispute between a Muslim individual and the government, as far as Waqf property is concerned, they argue that the Waqf, the senior government official or the collector will definitely side with the government. So in this case, the government becomes both the litigant and the judge. The Supreme Court has taken a very serious view of that, found prima facie evidence in that, merit in that argument, and has said the supreme power given to the collector. And one of the most important issue is that the Supreme Court stated the rule that one should have practiced Islam for 5 years before making a Waqf donation. In fact, and also provision state till state government frames rules on determining whether a person is a practitioner of Islam or not. Very important. Okay. And Supreme Court has also said Central Waqf Council shall not consist of more than 4 non-Muslim members, and for state not more than 3, which means that Supreme Court has not completely agreed with the plea of the petitioners.
So as we are waiting, as far as the detailed copy of the judgment is concerned, Shardaji, what is your point of view? Because we have multiple live reactions also coming in, so we'll cut to them. But do you view it as a balanced order that has been given by the Supreme Court today?
First of all, I would say that, delaying the judgment by passing interim orders in such a long drawn case should have been avoided, because every evidence has been presented, every argument has been made. So earlier the judgment comes, it is better for everybody concerned. So suspense and this political one-upmanship goes. Now coming to the issue of collector's power, wasn't the earlier Waqf bill so much in favor, giving power to the local Waqf board that they could put their finger on any land and claim it to be there, and it had to be challenged within the Waqf board itself? So at that time, weren't the judge and the jury also? So this particular argument doesn't hold water. Secondly, that they are clutching to the straws. Profess Muslim for 5 years, etc. Fine. It doesn't go either way, this way or that way. But major issue that there is a total stop of loot of the land, as the Ashwini pointed out. 40 lakh acres is under litigation. Temples are under litigation. Gurdwaras are under litigation. So this misuse of the power had to be stopped. That is stopped. That is the biggest decision that we can talk about. And as you said, no third-party rights can be created. It also goes in favor of the people who are sufferers on the other side. And I think let people be happy. If everybody feels has good judgment, great. But having a collector, a government person to have power more than the Waqf board is not negating the law.
Because the entire act was actually challenged. Now, what the Supreme Court has come out to, especially when it comes to certain sections, 3R, 3C and 14. Now, they have been saying that they have gone to the legislative history and has considered prima facie challenge to each section, and hearing parties were not made out for the entire statute. But there are certain sections under that has been challenged. However, this provision of granting a stay that has been extended. Tosi, if you want to come in.
Yes, you see, it's a wrong notion to say that the entire the bill was challenged, because once you go into the petition, you will see specific clauses have been challenged. Secondly, why this curtailing the power of the collector was important, because in one notification, by putting the property in a disputed category, they were actually taking away the status of the Waqf property. The Waqf property, once declared disputed, was to become, was to go out of the purview of the Waqf board and was to be treated as a non-Waqf property. Therefore, this was very, very important. Okay. It was a very crucial and illegal, in a way, completely unconstitutional provision.
So the Supreme Court also mentioning, as far as the clause is concerned in the law, that only person practicing Islam for at least 5 years may declare a Waqf.
In the order itself. Second, that registration of Waqf has not been stated. Third, that the revenue officer's report before the DM cannot be basis to divest any Waqf owner of the Waqf property, meaning thereby he will have to go through the legal procedure before the tribunal as well as before the Honorable High Court. If that judgment comes in favor of the government, then only that gentleman can be deprived of the Waqf property. It is no longer Waqf property. Fourthly, that those who have not practiced Islamic law for 5 years, they were not permitted to create Waqf. That provision has been stated. So this is, therefore I have said, this is win-win situation for both. But largely it comes in favor of the move of the government and in favor of the non-Muslims.
All right, reactions that has been coming in, but yes, what is being said by the Supreme Court that the entire act was challenged. However, when it comes to prima facie, looking at the challenge to each section and hearing the relevant parties, it was made out that the entire statute need not be challenged, but there are certain sections that have been challenged for which a stay that has been granted. Now, as far as when it comes to sweeping powers is concerned, both Ratan Shardaji and Tausif has raised that point. Let me go back to Harish for a better understanding. Sweeping powers granted to the district collector in the new law, the court has taken cognizance that this cannot be permitted, especially when it comes to adjudicating the rights of personal citizens, and this will violate the separation of powers. Harish.
Yes, that's right, Amita. In fact, the Supreme Court bench agreeing with the contention of the petitioners. Remember, there were several petitioners that included Asaduddin Owaisi, Jamaat Ulema Hind, Mahua Moitra, RJD, CPI, CAPM. They said that giving the collector overriding powers to resolve a dispute, that is again separation of powers. Remember, as per the Waqf Act, once the collector is seized of an issue, seized of a dispute, that particular property ceases to be a Waqf property. And they had questioned, they have said that definitely a senior government official like the district collector will definitely side with the government. So in a dispute between the government and an individual, if the collector is given overriding powers, the government becomes the litigant and the judge. The Supreme Court found merit in this argument and said that, very clearly said that, till adjudication happens by a tribunal, no third-party rights can be created against any parties till the Supreme Court finally adjudicates on the 100 petitions before it. And as you rightly said, the Supreme Court has said that designated officer making challenge and
reactions have already started to come in. Mr. Kalyan Banerjee is also connected with us. Mr. Banerjee, what is your point of view as far as the Supreme Court today, which is declined to stay on the Waqf Amendment Act in its entirety, observing that no case has been made out for such sweeping order?
Listen, this is an interim order.
Yes.
Normally, when an act is challenged, no interim order is passed. But here, and some interim orders have been passed which are very important interim orders. And that is also, I see it is a very serious one thing, very good thing. Number one, that the collector, which we are saying that collector or any other officer of the state government cannot decide the right title and interest of the land in question. That part has been stayed. That's a major victory. Second is that we have said that the Waqf Board and the Waqf Council, the minority members are minors. Non-Muslim members have been made more. Thereby, the Waqf board's function has been, through the Muslim, has been taken away. That has been also restricted, that non-Hindu members, only few that has been given. That's also a major victory. Third is that the 5 years Islam, profession of Islam 5 years is compulsory for making the Waqf. That has been also stayed. And also the disputes which are pending before the tribunal.
But Mr. Banerjee, do you
and no
believe that
third
as part
party
of
right
the
will be
JPC,
created by that?
Mr. Banerjee, you had raised the issue, calling the purpose of the bill as a clear breach of the right of the Muslim community to perform their religious duties and manage their religious affairs. And that is why you had called it a complete violation of Article 26 of the Constitution. That purview hasn't been taken up by the Supreme Court, sir.
Pardon?
As part of the JPC, sir, you had called, as far as this act is concerned, the purpose of the bill at that point in time as a clear breach to the right of Muslims to perform their religious duties. However, that seems that the point has not been taken up by the Supreme Court, sir, as far as the entire act to be challenged.
Listen, madam, this is an interim state. No final determination has been made whether Article 26 has been violated or whether any other provisions have been violated. That cannot be decided at an interim state. If our argument was not accepted, then in that case, how the Waqf board and the Waqf council, non-Hindu members have been restricted now by the Supreme Court. That directly and indirectly, directly or indirectly has upheld our contention regarding the Article 26.
So you're claiming vindication on your part. Thank you very much, Mr. Kalyan Banerjee, for joining in on the broadcast. Ratan Shardaji, Tausif and Harish also continue to be with us. This is a big development. Of course, we are waiting for the entire judgment to be out so we can better understand exactly when it comes to the Supreme Court and a stay that has now been granted to certain provisions in the act itself. But the act which was challenged, there has been no stay on it as a whole in its entirety. We will get you more reactions back after a short break.